But today we're going to talk about, that's me. This is my web page. And the reason I put that up there is I have a lot of stuff on the web page that will interest you. So including a download, a free download of a book that this presentation is based on. Okay?
It's a very big book. Just bear that in mind. You'll need lots of papers.
So let us give children and families what they need instead of what we've got. So what we're going to do today is we're going to examine how the reasonable efforts tool can achieve better outcomes. So here's the first situation. At a shelter care hearing, the attorney for the mother asks you, and that's you, the judge at this point, to order a social worker to be present in the home 12 hours a day. She says that will permit the child safely to remain at home. The agency attorney objects, but the guardian ad litem supports the request. And the question becomes, how are you going to rule? So I want you to turn to your friend on either side, get groups of 2 and 3, and I'm going to give you 1 minute, and you're going to come up with answers of how you're going to rule on this. 12 hours a day, a social worker, okay? Do we have, by the way, do we have a county council in the room? Who's going to confess to being a county council? Great, you're answering this question. No, lock the doors. Now I want to hear noise. I want you to talk to each other about this issue. Okay, the time's up. Time's up. County Council, what are the arguments against this?
We're wasting county resources and funding.
Wasting county resources.
Spending, excuse me. It's getting hot here.
But we are preventing removal. We're keeping this family safely together. Isn't that a good social goal?
It might not be possible to offer all the services the wraparound services that we want to offer the family just with one social worker being there.
So you say that's one answer. What about for the parents? They say these services are necessary to prevent removal. But you say these services cost too much. That the agency has an obligation to serve the whole community, not just one family, and we have to balance our resources. What happens if I told you, is that the job of the agency to provide services to prevent removal?
I would answer yes.
Yes, the answer is yes. And the question then becomes, how much? And that's what we do in court, isn't it? We decide how much. And what would happen if the judge decided, yeah, the agency must provide this service, and you refuse on behalf of your client? What's the finding the judge might make? What are the magic words the judge might say? Let's hear it. No reasonable efforts. That's what this talk's all about. What if I told you that the social worker only had to spend 12 hours for 1 day? Would that be reasonable? How many people think it might be? I have a colleague in Kentucky who does this, puts a sheriff in some of the domestic violence cases, puts a deputy sheriff in until things have calmed down, usually for overnight. And I think that's very reasonable. But indefinitely, that's not reasonable. And somehow we're going to be drawing lines here about what's reasonable and what's not. At a shelter care hearing, the social worker recommends that the court remove the children because the mother is homeless. Is that a reasonable efforts issue? Turn to those same people that you've become acquainted with and talk about this. because I need some answers from people, and I won't call on county council this time.
It's the agency's responsibility to create housing in this city, because we have none, and that's the reason why people are
Okay, we're gonna talk to this team right over here, and that's right, turn away. Is this a reasonable efforts issue?
Is that a, no, I don't think so.
Why not? Why not? Does the agency have a responsibility to try to find housing for that family? That's the question. And is that a reasonable efforts issue? You're nodding yes back there. You're right. Sure, it's a reasonable efforts issue. The agent, look, why do we have we have any social workers in here? No. Do you know what the job of a social worker is when they go out in the field and they discover a problem? Is to protect those children, make them safe. And if homelessness is the issue, we don't have any big cases in California, however, on this. But number of states, and Washington's the most famous, have class actions on the homelessness issue. And there's no question, but California does something else. California does 300B, which says the social worker must provide temporary shelter. This wasn't a class action. This came out of the legislature. And we have several cases, and you have page 131 of the reasonable efforts. I have a discussion of it there. And also check WNI 11450. By the way, if you want a copy of this WNI, this PowerPoint, just email me, and I'll send it to you, okay? At a review hearing, the mother's attorney asks you to order the department to provide transportation so that mother can visit her children. The agency says, we don't have the resources to do so. This would be perhaps San Francisco to Laurie, because the child is placed out there. Is that a reasonable efforts issue? Wait. Turn to your colleagues and talk about this. Come on. You're not talking back there. They got the answer. All right, time out.
clear.
In the back row. Yeah, what's the answer?
Yes, it is. Clearly,
All right. Of course it is. Visitation. Is there anything more important than visitation?
No.
Why is it important?
Because you're never going to reunify a family unless they visit each other.
And what happens in visitation?
Well,
You stay connected. I knew families that when they didn't get visitation, gave up. They gave up. And the kid gave up. Is it the responsibility to provide services that will promote reunification of a family? Absolutely. Absolutely. And I'd be surprised if visitation didn't come up at every judicial hearing. We want overnights. We want unsupervised. We want 2 rather than 3 hours. Well, I mean, 3 rather than 2. This is something that you talk about all the time. So what are the possible rulings? What are the tools that a judge has to encourage and facilitate change in the child welfare system? Reasonable efforts is, in my view, the principal tool. Reasonable efforts and no reasonable efforts. So where do they come from? Well, they come from the Adoption Assistance Act of 1980, That was when the federal government turned everything upside down. And they brought the courts in for better or for worse. And courts went from having 1 or 2 hearings in a child protection case to as many as we have now, and that can be 10 or 15. Then the ASFA in 1997 added a third reasonable efforts issue. The first 2 were to prevent removal and to facilitate reunification. The third is to promote timely permanency. So how does all of this work? Well, California submits to the federal government, all states do, a plan. And they say, if you pay for foster care, we'll provide all these services to prevent removal and facilitate reunification and to promote timely permanency. And here is our plan. Here are all the things we're going to give. I have a copy of the state plan there. It's incomprehensible, but there it is. And the federal government says, okay, you're going to do all these things, and then we'll give you all this money. Billions of dollars goes out to the states to support foster care. They pay a percentage of foster care costs for these different counties in California, states in other parts of the country. But we're also going to take a look and see if you are providing the services that you promised that you would give us in the state plan. And how are we going to do that? Well, we're going to have audits, and they will look generally at the system, but we're also going to look at court files to see whether the judge has written in and made the findings required by state law and by federal law. And what are those findings? Well, the key finding is reasonable efforts or no reasonable efforts. So these are the findings the judge has to make. In a removal, contrary to the welfare of the child, we talk about detriment, but this is the federal language. Reasonable efforts to prevent removal, reasonable efforts to facilitate reunification, and reasonable efforts to finalize alternate permanency plans. That's fancy. I just say timely permanency, but that's guardianship, that's adoption. So what does reasonable efforts mean? And I'm not going to ask you that because there's no good definition. Here's what California Rule of Court says. Those efforts made or services offered by the county welfare agency or probation department to prevent or eliminate the need for removing the child, to resolve issues that led to the child's removal, or to finalize the placement of the child. That's what I just said, but they put it in a rule of court. Or we have a case. We have the Riva M case, which goes pretty far back. Has the Child Welfare Department, quote, identified the problems, offered services, maintained reasonable contact, and made reasonable efforts to assist the parents where compliance proved difficult, such as helping to provide transportation. So we've got a definition. It's pretty general. Oh, and we can also go to the Child Welfare Information Gateway. You can Google that. And they say reasonable efforts are accessible, available, culturally appropriate, that are designed to improve the capacity of families to provide safe and stable homes for their children. This is the business that we're all in. So if you go to page 364 of this book that we're going to talk more about later, I've got the definitions from every state that has a definition. Several states don't have definitions. Essentially, when a court makes a reasonable efforts finding, the court is telling the agency and the whole world that the agency has either done its job and completed its responsibility towards the clients and its promise to the federal government, or it hasn't. It's a term of art. There's no fast and firm definition. It is the amount of services or social worker effort that the law requires depending on the problem and the resources within the community. What may be reasonable in one community may not be in another. Yet there's a minimum amount of services that every agency must provide, urban, rural, rich, or poor. I'd say that visitation is one of those things. You've just got to do that. So here are the 3 findings, and here's the timeline. We've got to make these reasonable efforts findings within 60 days after removal. You make the reasonable efforts to prevent removal. At the disposition, if the child has been removed from the home, and after a permanent plan has been set. 1, 2, and 3. We've got 3 different types of findings, 3 different times they might be made. They must be made. Now here's the no reasonable efforts. The agency hasn't done its job, not provided the services and supports that it should have, and what happens with the no reasonable efforts finding? The agency loses money. There are 2 kinds of ways of losing money. If they didn't prevent removal, they lose money for the whole case. If they didn't provide reasonable efforts to services and supports to reunify the family or for timely permanency, they can get the money back by repairing the work that they didn't do right the first time. Yes?
Is that still true with the block grant?
If the block grant is a slightly different analysis, and we'll talk later, you and I can talk about it. Is San Francisco a block grant? Okay. It's still an important finding, and the agency will perk up and pay attention to it, but it's a different logical analysis. So, here we have another situation. There's physical abuse of a minor and siblings, and led to the removal of the children. At a combined juris dispo, the court removed the child and found reasonable efforts to prevent removal had been made by the social worker. This is an actual case. And it was reversed on the Court of Appeals. Because during the time before the dispo, the mother had been convicted of child abuse in the criminal court, placed on probation, and the social worker said, you know, the mom's getting it. She knew she had a problem, and she was working on it. The appellate court said there wasn't substantial evidence to support the reasonable efforts finding. The social worker's report did not discuss what, and this is from the statute, what reasonable means could have been provided by which the children's physical health could be protected without removal. Moreover, the trial court failed to state the facts on which the decision to remove the child was based. Must the trial court do that? You betcha. It must, quote, make a determination as to whether reasonable efforts were made to prevent or eliminate the need for removal of the minor from his or her home. The court shall state the facts on which the decision to remove is based, and that's right from the statute. This is the most important case of 2014 for me, the Ashley case. Most important case because it's not just about this case. It's how we should behave in court. Social worker has to write a report that talks about what services were provided to prevent removal, and the court has to make a finding. Yes, such and such services were provided, and that is reasonable. A child is removed from a mother's custody after the social worker discovers that the mother has been the victim of repeated domestic violence and that the child has been exposed to that violence. Is there a reasonable efforts issue involved in this case? Why don't you talk to your colleagues and see if you can find a reasonable efforts issue? Okay, who's the DV expert in the room? Sorry about that. Who's the DV expert here? Who have we got? No, you've already talked. I want somebody else. All right, good. All right, what could the social worker have done to prevent removal?
Assist the parent, the mother, with getting a restraining order and kick-out order from the court, remove the offender, and assuming it is the other partner who is the abuser, or if it's not, remove the mother if she's the offender,
Um,
Your Honor, this is a detention hearing involving a child, Andy. The Department of Children's Social Worker, Mr. Finney, is present. He is represented by Deputy County Counsel Ms. Jacqueline. The mother is present and is represented by Ms. Silver. And the father is present and represented by Mr. Franklin. The child is represented by Mr. Toby. The child was removed from parental custody, Your Honor, on Tuesday because of domestic violence in the home. The social worker is requesting that the court detain the child as it would be contrary to the best interest of the child to be returned home.
Thank you, Mr. Thomas. Good morning, everyone.
Good morning, Your Honor.
I understand that the parties stipulate that the court may consider the police reports and social worker reports without further examination of the preparers of those reports. Is that correct?
Yes, Your Honor.
Is the matter submitted?
No, Your Honor. We believe that the social worker did not exercise reasonable efforts before removing the child. Moreover, circumstances have changed in the past 72 hours. We believe the child can safely be returned to the mother's care.
Please explain, Ms. Silver.
According to the reports, the police were called due to a domestic violence incident. When they arrived, the mother was injured and under the influence of alcohol. Father was present also, as was the child. The police arrested the father and the social worker removed the child. The social worker could have placed the child with a relative, the maternal grandmother, whom the child knows well. Not doing so was a violation of his duty to place the child in a family-like setting and thus preventing removal of the child into foster care. There have been significant changes since the incident 3 days ago. The mother now lives in a domestic violence shelter. She's filed a request for a restraining order in this court, and she would like the child to be returned to her immediately.
Mr. Finney, do you have any comments on the remarks that Ms. Silver just made?
Yes, we're concerned that the mother will return to the father and once again place the child in danger.
We can assure you, Judge, that Ms. Wentworth will not return to the father. She's filed for divorce.
Is the matter submitted?
Yes, Your Honor.
I rule that the child shall be returned to the mother immediately on condition that the mother participate in a substance abuse program and that the father have only supervised visits 1 time a week for 1 hour. Based upon the social report and the police report, I issue a temporary restraining order restraining the father from contacting, harassing, annoying, battering, or otherwise disturbing the peace of the mother. There will be a hearing in 15 days to determine whether I will make that a permanent restraining order. I find that the agency did not exercise reasonable efforts to prevent removal, considering the circumstances of this case. Mr. Finney, I have talked to you about these issues before. First of all, the child should have been placed with the grandmother pursuant to Welfare and Institutions Code section 361.45. Second, the grandmother is a preferred placement pursuant to Welfare and Institutions Code section 361.3. Thirdly, the physical removal of the child occurred just over 3 days ago. Much has changed since the removal. I am ruling on the situation as it appears before me today. That concludes this hearing. Thank you very much. Book County in Santa Clara, just as you were here in San Francisco. And we suggested to the legislature at one point that they give juvenile court judges the ability to issue restraining orders based just on the documents at initial hearings. And so there are a lot of teaching points here, and I'm not going to go into all of them right now, but here are New York, in my view, has the reasonable efforts on the domestic violence issues down better than any state. We do pretty well in California, but New York does better because of the Nicholson versus Scopetta case. And if you haven't read it or seen what happened in the federal courts there, and you're really interested in these issues, I cover it a little bit in the book, and you can look up the cases. So, An attorney for a teenage mother asked the court to order the agency to place the mother in a foster home that will accept both the mother, who is a dependent, and the baby. Would the agency's failure to do this be the basis for a no reasonable efforts findings? So talk with your colleagues about this factual situation. Isn't this fun? Okay, everybody, we're moving on. You guys are really bright, so I know you don't need that much time. This group here, this threesome, who's going to speak to this?
We do think it's a reasonable efforts issue.
Yeah, and do you think that in your community, do you think that it is pretty clear that they should be able to find someone?
Yes, we do.
Yeah.
I mean, they exist. We're not in Kansas.
Yeah.
Well, that's where the placement's going to be.
It might be fine to be in Kansas. No, I think that they can do it. I mean, it's done with.
And so if the social worker came into court and said, we took a look and we can't find any, you would press that issue, wouldn't you?
I would.
Okay. Okay. I think that some counties might be a little more difficult. But in San Francisco, I don't think this is a pretty easy one, I would think. At a dispositional hearing, the social worker writes in her report that she's not located the father or any relatives. Is this an issue that the court should examine? Could that be a reasonable efforts issue? Back to your tables. Come on, you two, you guys talk. Come on, I'll introduce you.
They have to report on family
You guys got it? You ready? Who's going to speak? All right, we have volunteers in the front here. They say they've got it cold. Yes, sir.
Well, I didn't volunteer, but I guess we decided that, the expectation is that the social worker and the agency will undertake a fairly thorough search. Reports like that all the time are searches for parents, and it's a reasonable efforts issue only to the extent that they didn't conduct the requisite search.
Well, they actually submitted a piece of paper that said they looked at the DMV records and the tax records and couldn't find him. Is that enough?
Well, then I think it would be.
What?
Well, wait.
Department of Motor Vehicles and the tax records and the home ownership records. Well, what would you, you're cross-examining now. What are you going to ask the social worker? Did you fill in the blank?
Did you check if the parent is incarcerated anywhere?
All right, that's a good one. Anything else? Who else has something to ask? Yes.
I would ask if they had contacted any known relatives.
Well, they don't know if she said she didn't. It's father and relatives.
Right, but the ones that they do know about.
Oh, it's the ones they do know about. Okay. All right. Possible. Yes.
Did they do the inquiry of the mother?
Did they ask the mother? Let me tell you. How many mothers have you met who want nothing to do with that guy?
No, but they still need to ask.
Well, that's right. And she says, I don't remember.
And then do you ask the kid? Did you ask the kid?
and the kid's too young. Yes.
These days they need to look on the internet. I think they need to do Googles, they need to do Facebook, they need to do
All right, now we're starting to talk. If you want to be creative about this, you do everything you've talked about, Facebook, private investigator, and what's contained in the federal legislation, the 2008 legislation, as a best practice, family finding. Ask the agency if they used family finding. Family finding will come up with 150 relatives in half an hour. Now, engaging them is something else. But don't let this one slip by Department of Motor Vehicles and stuff like that, or posting in the legal journal. Huh? That's my favorite. Moreover, that we've got a little bit of case law on this. The AJ case from last year, 2 years ago, has to do with the reasonable efforts to locate the father. This 309 is all about relatives and what you have to do and what the social worker has to do. And you got to hold your feet to the fire. We have new cases on this that are saying, social workers, you've got to do more than you have been doing. Social worker duties with regards to locating relatives. This is important. And how many of you just represent children? All right, let me tell you what I've discovered. I work with the National Association of Counsel for Children. I've looked at reasonable efforts cases from over the country, thousands of them. Children's attorneys don't appeal cases, okay? They just don't do it. They don't see it's their role. They think it's the parents against the state. And yet, does a child have an interest in finding the father and the father's family? The father may be not very attractive, okay? But his mother, his aunt, his relatives, there are a whole bunch of reasons. That's a different talk I give on why engaging fathers is so important. Okay, new situation. The child has been removed because of parental neglect. The caretaking parent is Native American and has a serious substance abuse problem. The social worker's report indicates that she offered services to the parent in order to meet the reasonable efforts requirement. What is the issue here? This is a trick question. I have somebody who's already given the answer out loud. What is the problem here? Active efforts. And what are active efforts?
It's a higher standard than reasonable.
Not in California, according to the Michael G. case. I'm writing an article on it now because I think it is a higher standard in all other states but Colorado. But active efforts, where does it come from? Indian Child Welfare Act. It says you must provide active efforts to prevent removal. And so when you have a case with an Indian child, you don't talk about reasonable efforts. You talk about active efforts, and then you try to persuade the judge that active efforts is a higher standard than reasonable efforts, even though the California appellate law says it's not. You can look in the book, and I have the Michael G. case discussed there. Well, it's right there. You see, you open this little thing. These are all the California cases. And the ICWA cases appear on, well, it's not numbered. It's number 17. And Michael's case is on page 18. Michael G. is right there. Okay? Yes?
Is that active efforts just triggered by the parent saying that the child may be an Indian, that ICWA might apply? Because
all right,
it's not going to apply until the detention. Or
back up a step. First of all, who determines whether it's an Indian child? The tribe. There's an appellate case which says something different this year, but we're going to just push that aside. The tribe says so. And once the court says this is an Indian child based on what the tribe says, then the Indian Child Welfare Act must be followed. Okay? That means a whole new set of procedural rules, including a different definition of reasonable efforts. It turns into active efforts. And so active efforts is the term in the Indian Child Welfare Act, and it means, to me, it means more energy, more services, higher quality, culturally competent, engaging the tribe. All of these things are built into the law, including the California rules of court. And so the court is then being asked, can you make a finding that the social worker provided active efforts? And you look at the facts of the case, and the court would make that decision.
But you're not going to get that until the court finds you've got an ICWA child.
Sure,
So
but you can do that at the shelter care hearing, and you make the prevent removal finding in the first 60 days. So that could be at dispo, depending on how fast the case moves. You see, the court must determine whether these services. Well, I just said that. Thanks to you. All right. If you want a discussion of this, there's not only what the appendix that you have, but also I tried to cover all the states. This is a national book. The judge receives an affidavit. Now, those of you who are not judges don't know about this, perhaps, but county council knows. I'm going to, yes, wake up. Yeah, that's right. So what happens is county council makes an affidavit, helps the social worker fill it out, and they take it before a judge on an ex parte basis, and the affidavit is in support of removal of the child. Do you do that in San Francisco County on occasion?
I'll let Mr. Senator answer.
You agree with them, though, don't you? All right. And why do you have affidavits? It's to avoid lawsuits. Because if a judge signs the order, you can't sue you can sue, but it won't be effective. But if the social worker takes the kid, you can have a lawsuit. And social workers have lost big time in that forum. And so on close cases, they bring an affidavit in. Well, I used to get affidavits, and the facts are generally sufficient to justify removal. Is there anything else the judge should be looking for in the affidavit? Come on, now what are we talking about today? Yeah, how about the social worker saying, I tried this, I tried that, and I still had to remove? The judge should be looking for efforts to prevent removal. I think you did that. That's right. Thank you. At a dispositional hearing, the social worker submits a report with a service plan. Is there anything you, either the attorneys or the judge, would like to question the social worker and the parties about the plan? So discuss this for a minute. This is an important series of questions that follows this hypothetical. So, you guys got it? Sure. All right, who's going to do it? You're going like that? All right, we've got an answer here, and what else are you going to ask?
Well, I would want to know what was the process that went into making that plan? Were the parents involved? In some cases, were the minors involved in developing that plan?
Is that necessary?
I believe it is.
This is such a good answer that you are going to be the first recipient of a copy of the book. The Code of Federal Regulations, which is all in the book, a case plan for each child must be a written document, a discrete part of the case record, in a format determined by the state, which is developed jointly with the parents or guardian of the child in foster care. You got to find that out. If it's not, it's coming back. It's an appealable issue, yes.
But what import would it be to the court that these case plans are written up, word processed, might I say, signed by the worker, sometimes a wonderful person, and the supervisor, and no parent has signed it, although there's an agreement they're all going to do it together?
Court shouldn't accept it.
Yes, that's 100% of our cases.
All right. Because of the light bulb that just went off in Miss Brule's head, her family gets a copy of the book. We're going a step further. Oh, I just stepped on the microphone here. I hope it still works. Sorry. You should examine the specifics of the case plan. Be certain that the services are available and appropriate. And why do I say that? I say that because of Taylor J. 2014, when it turned out that the social worker handed the mother a list of counseling services, one of which was appropriate. Every other one was either gone, wasn't available, or didn't offer what the judge had said the counseling should offer, and were not convenient. And if that is simply not reasonable efforts, you've got to examine whether the services were available pursuant to what the judge has ordered. So you've got to look at that service plan and see if it's practical. The attorney, GAL for a child, asks the court to order wraparound services to make it possible for a child with mental health problems to remain at home with her family. The agency argues these services are too expensive. What is wraparound, and is it a basic service? Back to the table. He stepped on the microphone too. Okay. You know, I don't remember that interview with Tracy. It's me speaking, I'm sure, but I don't remember the interview. Every once in a while, he would call me up and we'd talk, but okay, I see people very. Yes. Which one of you is going to speak? This lady. This lady here? All right, fine. You obviously have a good friend there.
We're lucky in San Francisco that I haven't generally had a hard time getting wraparound services. I was saying that often depending on the worker, it can take a long time before you get it, before they'll take you to the mat.
So the agency has wraparound services. Do you know how many slots they have? That's a question you need to ask. By the way, I highly recommend having the agency put on trainings explaining what services they have and how many of them have. So the questions you would ask in wraparound are, how many slots do you have? And those of you who do delinquency law, how many slots do you have on the delinquency side? And then you need to ask, what is the quality of rep? Is it 9 to 5 rep or is it 24/7 rep? Because they're qualitatively different. And we used to have arguments in court, I'll send this kid home with 24/7 but not with 9 to 5. And so that's another thing you have to debate. RAP works. RAP is really cool, but you need to know what's there so you can argue intelligently to your judge. Yes?
I feel like we get RAP really easily, but I don't think it's used as a way to prevent removal that frequently. I feel like they help children who are out of the home more frequently than they do in the home.
Yeah, I think that's right. Usually it takes a while for the agency to get things going, but once you have embraced RAP, as our county did about 25 years ago, because it all came out of a particular agency which was in the county, then they become better at it. And what we did was we removed all kids from private institutional care. That's one of the results of wraparound services, is that you reduce. It's expensive, but private institutional care is more expensive, as you know. Yes?
Do you think that the court has the right to order that? Because I find that the Seneca, that our RAP
happens, and the earlier it happens, the better it is. And I
Sometimes there's some stability issues. Sometimes the parents have to do a few things before they're ready. It takes a while to collect a team. You understand the principle of RAP is that you get a team, more locals than professionals, and the team RAP services so that the kid is covered 24/7, so that somebody is with him or her. And it takes a while to put that together. It's not going to happen in 72 hours before a shelter care hearing. It's just not going to happen. You have to back up a little bit and prepare. And you also have to prepare the kid for it. But usually I don't think it's realistic to think of it happening at the front end of the case. But that training, yes, but you don't snap your fingers and have RAP. RAP takes work. You have to persuade the teacher, persuade the coach, persuade the neighbor that they're going to be involved in this kid's life. And that takes time. And the RAP team may be overwhelmed. But have your agency give you a presentation on wraparound services in San Francisco so you understand the timing as well as how many spots they have. Another movie.
Your Honor, this is a 6-month review of the dependency of Freddie Oswald. The parents, Ms. Oswald and Mr. Franklin, are present in court with their attorneys, Ms. Yancey and Mr. Sisler. County Counsel Ms. Jackson represents the social worker, Mr. Finney, and Mr. Dickens represents the child who is not present today. The recommendation is for continued family reunification services, Your Honor.
Thank you, Mr. Thomas. Any comments from the attorneys?
Submitted, Your Honor.
Well, I have a few questions, Mr. Finney. Why have there been no unsupervised or overnight visits between the parent and child? I gave you the authority to move to unsupervised visits at the dispositional hearing. Your report says that the visits have gone well and that the parents have been fully cooperative.
Look, Your Honor, I continue to be concerned about what might happen in an unsupervised setting.
Mr. Finney, I order you to start unsupervised visits immediately and to move to overnight visits should the unsupervised visits go well. Further, I find that reasonable efforts to reunify have not been provided to the parents by the department. I will suspend the no reasonable efforts finding until I receive a report from you, the social worker, in about 30 days. If visitation goes well, I will consider striking the no reasonable efforts finding. That is all. Okay. That's what's known as ole. You show the possible penalty, and then you see whether they're going to make a change in the next 30 days. And guess what happens? It happens. That overnight visit or the unsupervised visits start. This is a technique that I've described in some detail in some other writings, and you get those references in the book. By the way, you can get the book on your iPad or on your computer. You can download it for free. And if you go to my website, they have the little things that you hit to do it. I'm not very technological, but somebody else figured it out. Okay, case study. A child was removed from parental care because the parents were developmentally disabled and unable to care for him. The parents received services and only supervised visits. They were fully cooperative. The child had an asthmatic condition. At the 18-month hearing, the court terminated services. The parents filed a writ, and it was granted by the appellate court. How many of you have personally filed a writ? Raise your hand. That's good news. I'm really glad to hear that. We have a unique system in California for challenging things by writ. When I ask that question in other states, nobody. The appellate court in this case held that the parents had been deprived of a reasonable opportunity to show they were able to parent the child. The visitation once a week for 4 hours was very positive, but insufficient and was never increased, just like the hypothetical film you just saw. Father was not offered the opportunity to demonstrate that he could care for the child safely. And mother was not provided services that were tailored to her physical disabilities. The parents were not invited to medical appointments. Very important. Get those parents involved with the medical appointments. There was no instruction of how to deal with asthmatic conditions, and there was no parenting assessment. So, send it back. Give them 6 more months, expand visitation, provide individualized services. Tracy J., very important case. But it's not the only one. California is the best state. We really should be proud of this. Stand for the proposition that the state has an obligation to provide reasonable services to mentally or intellectually challenged parents. We're always going to have parents who aren't up to speed intellectually, mentally. That happens in every state. What we do with those parents will vary from state to state. Most states are dismissive. And we have a series of cases, plus there are articles on my webpage that I write for the Judges Journal. We have a lot of cases that discuss these issues about what social services can do to work with these parents. And that's where they are. Okay, and that's a recent example in the KC case. And now we're going to come to our third and
Your Honor, this is a post-permanency planning period involving YPT. Parental rights have been terminated and there was no appeal of the court order. Present is the foster mother, Ms. Winter, the social worker.
This is a different mother. Same actress, different mother.
The recommendation, Your Honor, is to continue the plan for adoption.
Good morning.
Good morning, Your Honor.
Are there any objections to the social worker's report and recommendations?
Your Honor, when will the adoption be complete? I don't want to keep coming back to court, and I'm so afraid that the social worker will take Frankie away from me.
Your Honor, we're working on the adoption, and the child is living with Miss Winter. There's really no reason for her to be so upset.
Has the home study been completed?
No, Your Honor.
Are there any further comments?
No, matter submitted.
I find that the department has not exercised reasonable efforts to attain permanency as required by ASPA and the state law. I will continue this case for 2 weeks. Should the department have a completed home study, I will reconsider my no reasonable efforts finding. This child needs permanency. He needs to be out of the court system so he can live a normal life. We don't remember, we can't really picture the idea that when a social, even when this is an adoptive home, pre-adoptive home, and the kid's living there, when that social worker walks on the grounds, what's the fear? That's not permanent. It's not permanency until the case has been dismissed. That foster mother was in my court. This is an actual case I had in 1982 or 3, and she just stood up and did just what that woman did. And she's not going to be happy until she doesn't have to come back to court and doesn't have a social worker in her life. And we have some tools. And the reasonable efforts tool is the one we can use in that one. Once again, I use the come back in 2 weeks and show me what you've done. A perspective, this is the situation. And a no reasonable efforts discussion is certainly appropriate. Now, I'm going to skip ahead here because some people say that's the role of the judge to simply rubber stamp what the agency recommends. And what I like to say is, if you're in criminal court, do you just rubber stamp what the district attorney asks for? And of course, those of you who are engaged in criminal law, of course not. You challenge it. The parallel to me is very, very powerful. We don't just let the state get away with what it wants to do. We have to monitor the state. And the state is a very powerful force. But they have laws that govern what they should do and what they can do and can't do. And we, judges and attorneys, are the only people that stand between them and having their way, if you will. Well, in a very high percentage of the case, their way is the right way. But we need to question. We need to push the envelope. We need to monitor them. And I told you I did a study, thousands of cases. More than 97% of the cases the appeal occurs from a termination of parental rights. Well, come on. That's too late. It's too late because that means it's been a couple of years. Child's been out of home. Even if some kind of connection has been established. So what's our obligation? Our obligation is to make sure that we're getting services correct early. And so what I used to do, is have interim review hearings. Every case came back to court in 45 days or 30 days, depending on the age of the child, to see whether visitation's taking place, whether the father's been identified, whether psychological evaluations have been completed, whether ICWA has been fixed up, and more importantly, whether the parents are engaged in the right services. How about when they come in for a 6-month review, if you don't have interim reviews, and you learn that there's been a flaw in the case and nothing has happened? That is institutional child abuse, because this is an emergency. I compare these cases to the emergency room of a hospital. When the case comes in a hospital, everybody is working hard early now because it's so important now. Well, given the child's sense of time, we should all be working as hard as we can early in the case to make sure that we're doing it right for that kid. And this is the art of the no reasonable efforts finding. It's in the book. And some people tell me they don't think the reasonable efforts too is helpful to their clients. And I have that in your document there. A couple of very good parents' attorneys talk to me about that because they think that the no reasonable efforts finding doesn't help this case. And as I said, the reasonable efforts issue is not brought up often by attorneys, and many attorneys that I train around the country have never heard of it. This is not an issue that they ever think about. I think you ought to raise it all the time, because if you raise the reasonable efforts issue effectively, it may improve the whole system for clients. You might raise the water and everybody benefits from it, as well as the people in this case. I just said that. It should be examined carefully at the arraignment hearing, the jurisdiction, and at review hearings. And interim reviews can be, you can talk about paternity, visitation, services in place, ICWA, evaluation, and depending on, I have forms in the book for all of these issues. They're very simple. And usually the interim review, everything's going fine. And so it doesn't even take court time. You just nod at people. Sometimes there's a big problem, and it's you better catch it at 30 or 45 days rather than at 6 months. And that's a picture of the book. It's pretty nice. So here's my website, judgeleonardedwards.com, and there are instructions about how to download a copy. Don't write the National Council no, they just ran out. It's a popular book, huh? 4,500 of them, they're all gone. And once you let the members of your court system know that reasonable efforts is important to you and that you're going to raise this issue, everybody starts paying attention to it. It's amazing. The culture changes. Now, who here really would love to have a copy of the book and just has been denied and just feels like it would make your day? Yeah, I know. Too many people raise your hand. So I have one more copy left. And yes, you gave such a good answer, you get it. All right, that's all, folks. Thank you very much.